Can you be fired without a reason? Here is something that shocks most people when they first hear it. Your boss can walk up to you tomorrow morning, say nothing, hand you a box for your stuff, and that can be completely legal. No reason, no warning, no explanation at all. Sound unfair? Maybe. But is it legal? In most cases, yes. Let's talk about why. Welcome to Know the Law. Today we are breaking down one of the most misunderstood rules in American employment. Can your employer fire you without giving you a reason? The answer depends on where you work, what your employer may have promised you, and whether any protected characteristics are involved. By the end of this video, you will know exactly where you stand and what actually protects you on the job. The default rule most workers do not know. Let's start with the foundation. In 49 of the 50 states, employment defaults to something called at-will status. At-will employment means your employer can terminate you at any time for any legal reason without establishing cause and without giving you any warning. That is the default rule in almost every state across the country. And here is the part that catches people off guard. Under at-will employment, your employer does not have to provide any reason for your termination at all. None. They do not owe you an explanation. They do not have to document why. They simply have the legal right to end the employment relationship whenever they choose, as long as the reason behind it is not illegal. We will get to what illegal means in just a moment. So, if you've ever wondered why your manager never explained why someone got let go, or why HR just said it was a business decision, now you know. At-will employment gives employers that legal cover in most of the country, where the law draws a hard line. Now here's where things get really important, because at-will does not mean unlimited power. There are reasons that are absolutely off the table, no matter what state you are in. Federal law prohibits terminations based on protected characteristics. We are talking about race, color, religion, sex, national origin, age, disability, and pregnancy. These protections come from major federal statutes, including Title VII of the Civil Rights Act, the Americans with Disabilities Act, and federal age discrimination laws. These apply uniformly across virtually all states. There is no state that can override them. So if your employer fires you and the real reason is your religion, your race, your disability, or your pregnancy, that termination is illegal. Full stop. At-will employment does not protect the employer in that situation. The law reaches right through the at-will doctrine and holds employers accountable. Federal law also protects workers who engage in what is called protected concerted activity. That is a legal term that basically means organizing with coworkers to improve working conditions, including union activity. The National Labor Relations Act makes it illegal for an employer to fire someone because of that kind of activity. So if you and your coworkers start talking about wages or organizing, and you get fired for it, that could be an illegal termination. How exceptions under state law can protect you. Beyond federal law, many states have developed their own additional exceptions to at-will employment. These exist under what lawyers call common law, which just means rules developed through court decisions over time rather than written statutes. There are three major exceptions you should know about. First, the public policy exception. In most states, an employer cannot fire you for a reason that violates a clearly established public policy. Classic examples include firing someone for serving on jury duty, for reporting illegal activity by the employer, or for filing a workers' compensation claim. In most states, that kind of termination crosses a legal line even under at-will employment. This exception exists in most states across the country. Second, the implied contract exception. This one surprises a lot of people. In most states, an employer's own statements, standard practices, or employee handbook language can create what is called an implied contract of employment. That means if your handbook outlines a progressive discipline process before termination, or if your manager promised you job security, those things could give you legal protection beyond standard at-will status. Many workers assume handbooks are just guidelines. They are not always just guidelines. In many states, handbook language carries real legal weight and can override at-will status entirely. Third, the covenant of good faith and fair dealing. Some states go even further and prohibit employers from terminating employees in bad faith. meaning the employer cannot act with malicious or dishonest intent when ending the employment relationship. This protection does not exist in most states, but it is recognized in a meaningful number of them and offers an additional layer of protection where it applies. The key takeaway here is that the exceptions vary significantly depending on where you live. State law matters, and it is worth understanding what your specific state recognizes. A real-world scenario to bring this together. Let's make this concrete. Imagine someone works at a company for 6 years. One day they are called into HR and told their position is being eliminated. No documentation, no prior write-ups, no reason given at all. Under at-will employment, that can be completely legal. The employer is not required to explain themselves. But now imagine that 2 weeks before the termination, this employee filed a formal complaint about unsafe working conditions. Or imagine the employee is over 40 and was immediately replaced by someone significantly younger. Those facts change everything. The timing of the complaint could point to retaliation, which implicates public policy protections in most states. The age issue could trigger federal age discrimination law, which applies everywhere. What looked like a clean at-will termination suddenly has serious legal questions attached to it. This is why knowing the law matters, even when it feels like the employer has all the power. The bottom line. Here is what to take away from today. In almost every state, your employer can fire you without giving a reason. That is the legal reality for most American workers. But legal does not mean unlimited. Federal law creates firm boundaries around protected characteristics and union activity. State law in most places adds additional protections through public policy, implied contracts, and sometimes good faith requirements. If you were recently let go and something feels off, do not assume you have no options. The details matter enormously. If this video helped you understand your rights a little better, please hit like and subscribe so we can keep breaking down the law in plain English. Drop a comment below and tell us what employment law topic you want us to cover next. We read every one.